Edraos, Attorney Gordon.
May it please the court, I'm Joshua Gordon. I represent Joseph York, who's here in the back this afternoon. Mr. York sent 5 texts in 7 minutes, not in 13 minutes, in 7 minutes, with Mr. Edraos replying to all but one. It was a conversation. 2 of the texts were at the same clock time, and if you look at the either brief, you can see that, meaning there was less than a minute between them. And so even though we could see the order of the text, they were essentially simultaneous, several of them. A few minutes later, there was one additional text, but it was conciliatory, not threatening, and then it's done. And there's 5 texts in 7 minutes. To answer one of the questions before, probably my client was speaking into the phone, and you can see that in the 4th text, there's no need for DCYWHYF, so it was probably spoken. Under Mr. Edraos' theory, he would count each text separately, and the thread would constitute 5 separate acts. Under his theory, if I'm using my thesaurus and I utter a single sentence containing 5 threatening synonyms, that would be 5 separate acts. Or if I'm walking in the physical world, if I'm stalking someone down the street, you would count each step to each pace. I think that is really overly reductive and not what the legislature intended. Here we have one text thread with no break, and it's a single act.
Is that question a question of fact?
That it was a singular thread, I think, is a question of fact, yes, which gets deference to the trial court. I understand this court might want to borrow the standards from the harassment cases, and while the statutes aren't identical, I think the harassment cases provide a useful analysis. In Alex C., there was a 46-minute break in the messages. That's 2 separate acts. In DJ, the kid got off his bike and then said something further, and that's 2 separate acts. In Gubitosi, which was a stalking case, he drove around the restaurant and then later he phoned, and that's 2 separate acts. In all 3 cases, the acts were discrete, and that's the words in DJ, the acts were discrete, and they were separated by a break, and that word is in both Alex C. and DJ. Here, while Mr. York sent several texts, there was only one thread. And it's 5 texts in 7 minutes, several essentially simultaneous with no break in between. That's just one act, and this court should affirm.
And is that a matter of law that we should decide if we say threatening to break your arms off at 5:59 and pound you at 6:02 and break your face at 6:04? As a matter of law, we can look at that and say that's not, that is one act?
I think collectively, this conversation over the 7 minutes is an act. Had there been a break of a few minutes or 5 minutes, or had the 612 threat, instead of saying great, the 612 text, instead of saying great, had it been threatening, that might be a separate act.
It doesn't matter that those are threats of distinctly different harms?
Well, there's no finding that they're threats, and if it gets remanded, we'll learn that. But they are, Mr. York was upset about the treatment of his daughter, so he said these, or he texted these things or said these things into his phone. This conversation is a act.
So what if it's not a conversation? What if the plaintiff here hadn't responded to either of these threats? Would they be considered then separate, distinct course of conduct or not?
I think there would still be, I think the responses make it clear that there's a conversation, but if Mr. York had just texted 5 things over 7 minutes, I think it would probably still be, it's so collapsed that it is an act. If he had then waited a half hour and done it again, then it might be a second act.
As we consider what's an act and what might fit that definition, should we consider the purpose of the statute?
Well, of course. I think that's this court's job, but I don't think the purpose is fulfilled by parsing the statute in the way Mr. Edraos suggests, because it's so, it's just not the way human interactions happen, or whether it's in the physical world with walking, or on the phone, or in text. These things are dynamic, and I'm not sure that answers your question.
How do you respond to the conditional nature of the messages?
Well, we don't know that they're threats. There's no finding below that they're threats, and or whether they were justified, for that matter. And every single one of them contains the word "if," and so I think the argument, if this court reverses, the argument is open to Mr. York below that they are not threats.
Do you agree that a conditional threat can be a crime, a criminal threatening?
There are cases that hold that it can.
And how do we interpret the qualifier phrase, which evidences a continuity of purpose? Why is that there? If the two or more acts over a period of time, however short, is the end of the analysis, why do we have which evidences a continuity of purpose?
Well, I think perhaps Kubatosi might be a pretty good example of that, where the two acts were in very different modes. First he drove and then he phoned. And did they or did they not evidence continuity of purpose? And of course, the court found that they did. But I don't think that portion of the statute probably doesn't enter into this case, because the mode of communication is identical. I want to stress again that it's not 13 minutes, it's 7 minutes. And if that's all, I'll take my seat. Thank you.